Our next speaker is Chris SCALZO. Chris is the Deputy Public Defender in Greenville County. He also has served in the past as Interim Circuit Defender for the 10th Circuit. He is past president of the South Carolina Public Defenders Association. He's tried cases in all levels of court in South Carolina, so pretty much he can tell you all about it. And he's here to talk to you about what to do with your file when you get it. So, get you set up, Chris, then we'll... Good to go?
Great, thanks. All right, good morning. How are you all doing? My presentation isn't as lofty and goal-oriented, but it's practical, and I think that's a cool thing to kind of bookend us from inspiration to a practical approach to what we're doing. So I'm going to go to the next slide because that really outlines what my goals are. Very practical. Open your files, manage your clients and their files, because they're their files at the end of the day, and then analyzing your client's cases. And that's basically what I want to cover. One thing I want to say, and it's a little bit weird because my next presentation is about technology, but I really think that's all you need for the most part as a lawyer, and this little pen that I always have in this pocket pretty much at all times. Everything else is an added tool that might make you better, but at the end of the day, it's really all you need. And a lot of what I'm talking about here really gets you back to that. It's not to say you shouldn't use Defender data because they'll strike me down with lightning, or that you shouldn't use a computer or PowerPoint or any of the other things. I'm not saying that. What I'm saying is don't get wrapped up in what you have to do as far as technology goes, because at the end of the day, this is really what you need when you're talking to a client or you're talking to your jury or things like that. So everything I'm going to say is sort of an enhancement of that basic idea. All right, I want to talk about some general ideas before I get a little bit specific about handling your cases and being a public defender in general. All right. Be yourself, be neat, be organized, be consistent, and it's, kind of almost silly because it seems like that's what you would expect, but I think you forget that when you're in the heat of the moment. You're meeting with a client, you're in the jail, or you're in the middle of a courtroom, and you're about to go stand up to do a plea or in a trial, and those aren't really the things that are going to come to your mind. And if there's anything I'm trying to leave you with is this: all these ideas happen before you ever get into the courtroom, before you ever get to your office, and before you ever even get to talking to your client. Because if you're not thinking about those things ahead of time, and that's what you want to do, then you ain't going to be thinking about it when you're talking to your client who you think is crazy and won't shut up. And you can't get him to slow down enough for you to talk to him about what he needs to hear, or you to find out what you need to know, because he wants to talk to you about 7,000 other things that don't have anything to do with his case. That's the time you're going to rely on your instincts, and you got to get your instincts in line. So being yourself, unless no one likes you, and if you can't figure out who that is, here's the answer. If you're not a good person, be somebody else. That actually is true. Basic point is don't act. I remember I was in law school and we were doing a trial competition, and I was in Philadelphia, and there was this guy who was my age on the other side, and he was doing his trial, and every time he did his trial, I forget exactly what he did, but he did something very lawyerly, like he either did this, or he stuck his hands in his pockets, or he did the thing like this, and I'm looking at him going, there are no cameras in here. We're just supposed to be, I don't know, trying a case, but what's all the mannerisms and all that? And some people ate it up or whatever. It didn't work for him because it wasn't him. And it was very canned in that respect. And I know I remember being in law school, and some lawyers would come, they'd come talk to you about being a lawyer and all that, and things you could do to improve and stuff like that. And I remember an assistant U.S. attorney talking about taking acting classes. And I think for her, it worked because I think she was interested in acting. I think she may have even done some acting or whatever. And it never sat well with me, and then it took some time, and I've thought about it. Acting classes would be fine if they enhance who you are. So if they give you the ability to be a little bit better about the way you are and the way you are convincing, then they're great. But if you're taking an acting class to be a better lawyer because you're not going to act like a lawyer, that ain't going to sell so well, because people don't relate to you as an actor, they relate to you as a person. And you don't have a script that's all set out so all the lines will work out well in your performance. You're going to get curveballs, and so being you is really what this is about. And that's my point with this slide, is to really get you to be thinking about being yourself. Be yourself and steal as much as you can. That's really a big point. You're stealing it and making it your own, though, to stay consistent. So don't steal something just because it looks cool unless you can pull it off. I can try to think of an example, but I know a lot of times I've watched a trial and watched somebody do something, and I was like, wow, that was awesome. I ain't trying it, because it wouldn't work. For instance, this happens with a lot of older lawyers. If you got enough gray hair, you can get away with a bunch of stuff that I have a little gray hair that I still can't get away with. I always love the lawyers who would get in the courtroom and they'd have the witness on the stand and they'd be cross-examining the witness like this, and they're talking to the jury and the guy's sitting over there. To me, again, if you're 60 years old and you got a bunch of gray hair, you sort of could get away with that. Nowadays, I'm not so sure, particularly as a younger lawyer, that you really could get away with that. It may fit your personality, and so it may work. But what I thought was exciting was not something I've ever used. It just didn't fit the way I tried a case. And I try not to do that, to try to fit in something that doesn't help me try my case. All right, be neat. I'm not exactly neat. The really neat one is one of the assistants in our office. Chris will recognize the handwriting, and the one on the far side with the big triangle and all that, and that's my notes. They're not the neatest of notes, and it would help me to be neater. Where it really comes into play, I'll pick on Shipman because he's in my office. If I picked up Chris's file because I had to go in and stand in for him, am I going to find notes that I can understand or not? And I still do that. I write quickly sometimes, and it would probably be illegible to somebody else. So I constantly, 13 years in, have to remind myself to try to be neater than I know that I am. So again, it sounds like almost like a platitude, but unfortunately it is a real issue. Be organized. Is that you? That's me. Not a whole lot of difference. But that's not what I'm talking about. I'm not talking about what your desk looks like, obviously, because my desk looks worse than most people's. But what I'm talking about is being organized in your thinking and in your approach to what you're trying to accomplish, whether that is just simply talking to your client, talking to your client's family, whatever the thing you're doing right at the moment. You need to be organized in the way you're thinking about what you're doing and the way you're approaching what you're doing. I'm going to give you an example. All right. So what I do, and it's sort of in the next slide, but it's a presentation no matter what you're doing. Say for a trial is just a set of presentations, but for the most part, most of what we do, 90% of what we do, is a 5-minute presentation to a judge. And so guilty pleas, probation violations, bond hearings, all those kinds of things, they're little 5-minute presentations. All right, so what I do, you can see the two sides. The one that just expanded is not my handwriting, but my basic outline that I've used since day one, that I just intuitively started writing out. neither of these are required. I'm just giving you an example. The other one on the right is an approach that another lawyer in my office, I've seen her lay it out sitting next to her in court. You can use whatever you want to use. My point is, if you pick up any of my files, they will follow that pattern on your right, left, whatever one it is. But you'll pick up the file, and every time I pick up my file and I know which document, which piece of paper is the one that's my presentation, as opposed to all the other pieces of paper in my file that I'm like, have to sort through, not generally. That's my first page on top. And I always put it there, and I always do it, and I always have my pen right here, except when I put it down there. But if I'm standing up in front of a judge, I always put my pen here, because I don't want to be going like this as I'm talking to the judge and, you know, conducting an orchestra. But that is so that when I'm like, oh, what was I going to tell him? Oh, yeah. Not only do I look at the piece of paper and then lose myself, and if you all haven't done that, you're liars, but you look down and I don't know where I am. The reason I know where I am is because when I write out all my information, I write it out in the same order. So wherever I've left off in my presentation, if my brain just turned off for a second, I go, oh, medical. Oh yeah, medical is usually right in the middle after employment. I just know intuitively where the information is. That's why I do that. It's being organized by following a pattern. And make sure I don't forget something. Here's a good one, client control. I usually develop that little outline. A lot of times I'll follow that, particularly with probation violations, when I'm meeting with the person, because probation violations you get pretty good at pretty quickly. You don't really need to interview them, make a bunch of notes, and then rewrite your notes of how you're going to do your presentation. A lot of times you can just do that all in one, at least that, unless it's a really complicated case, but for the most part. So when I interview them, that's what I use. I just use my pattern. How long you been in jail? That goes up in the left-hand corner. Let me talk about if you're married, you have kids, all that stuff goes up in the right-hand corner. Let's talk about employment. Let's talk about what you did to violate, you know, misreports, and I'll just write down the alleged violations and go through those. If they've got explanations, fill those in. And I just progressively move down. It's client control, because the guy who wants to talk to me forever, I just literally go, hold on, bro, I can't. I got to write all this stuff down. You're moving too fast for me. And he sees that I'm not lying, and I'm not lying. And I'm not manipulating him into some routine, and it's not a game. It literally is. My brain doesn't move that fast on this information that I don't know. So slow down. I've never had a client be mad at me for that. Although I felt like when a client was talking to me, I'm like, oh man, he's going to be mad at me, or he's going to, I don't know what he's going to do. And I have this, used to get this anxiety about just stopping the guy dead in his tracks. I don't have a problem stopping the guy dead in his tracks, because I know I'm not going to be rude about it, and I know I have a purpose in doing it, and I'm going to show him my purpose. And I think that's important. And here's talking about just that, have a plan. Sometimes it's a little bit difficult to go in with a plan because you don't necessarily know what you're going to find, although circumstances usually will tell you. It's your first time at the jail and you're meeting with him, so you know there's some areas you're going to cover and some areas you're not going to cover. But as you're going through it, a lot of times you can develop a plan right as you're talking to this guy. You realize, oh, okay, this is the situation, okay, and you start developing your plan. I know I have done it in the past and sometimes still do, but try not to. It's my plan, so I act like it's my plan, and I don't tell him what the plan is. And so, but that's what he's desperately there after. He's either waiting for me to tell him what the plan is and how we're going to go about doing whatever it is he thinks wants to have happen, or he's going to be sitting there going, when's he going to tell me what we're going to do? And the more you do this, the more you're able to read people, the more you're able to figure out sort of what personality you're dealing with. Some people you just got to give it to them quick. And some people you can let ride out, and you got to figure that out. But you're never going to figure that out if you're not consciously trying to come up with a plan on your own and have some idea about what's going on. And how could you expect this guy who may think he knows how the process works or is honest and doesn't have any clue as to how the process works, how's he going to deal with that when you won't even share what's in your head about what your plan is? And by the way, your plan, it's okay to say, yeah, I don't know. All right, let's go to the next slide. See, this is why I don't like technology. Sometimes it doesn't work. Now it wants to close my program. All right, here we go. Let's see if I can get it. Same thing happened to me last year. I wanted to show something, and the YouTube wouldn't come up, so I had to act it out, which is fine. I'm talking about being consistent, and it goes back to my little outline that I had about the things you write down and things you're asking for, and it controls your situation. And the video is Nomar Garcia Power. He used to play for Boston and play for Los Angeles Dodgers. And every time he got up to bat, he would do the same thing. He'd kick his feet like that, and then he would pull on his things. And every pitch, he would do that. It could be 8 pitches, 10 pitches, and he would literally do the exact same thing every time. And I approach just about everything that I do from the same standpoint. And if I'm doing a preliminary hearing, I'm in trial. I'm in trial. It's not 10 minutes of, God, what? You know, like it's like drudgery, which is what the prosecutor thinks, which is what the police officer thinks, which is what the magistrate thinks. Sometimes your client thinks that, whatever, people watching. Consistency is important in my approach because bad habits will sneak in. Is not a bad habit because it's just it's a tick, but asking open-ended questions when you're doing your cross-examination is a habit. Usually reinforced when you're doing your preliminary hearing, because in your preliminary hearing you're like, oh, there are no rules. I could ask open-ended questions. I could ask cross. I can do whatever the hell I want to do. No, you can't. You can by the rules, but no, you can't by laziness, because if I'm doing a preliminary hearing, there are times when I'm asking an open-ended question, I'm asking an open-ended question because I know I'm asking an open-ended question and I know what I want to do. I want him to talk. I want him to really develop whatever issue I'm asking him about. But when I want to make a point, I'm using a cross. One fact-leading question and I'm getting to where I want to be. It's not just haphazard. While he may think it's haphazard and everybody else may think it's haphazard, it ain't haphazard for me. And that goes back to when I'm in trial. If I naturally just ask questions and don't make a conscious effort to be close-end, open-ended, then it doesn't matter, because my routine is when I ask questions, I could do whatever I want to do. And I will tell you, as I said, 13 years later, sometimes you just fall into a habit where you just all of a sudden want to ask a question a certain way because you get lazy. You're thinking about the next step or whatever it is. So be consistent. All right. Opening your files. They're usually open for you, probably by staff, but you're the lawyer and you're responsible for the file, just like everything else. You know you're responsible for it. So if you don't like the way it's being opened, then fix it. If it's being opened a certain way but it's not really being used the right way or whatever, figure out what you're responsible for and what your assistant's responsible for. I don't think there's anything wrong with that. Now, of course, there are personality issues that you've got to deal with, but that's actually your responsibility to figure out how to deal with them, unfortunately, because that's what you're responsible for. What should be in your file, I don't know, I guess it's really up to your boss, but if you don't have any ideas or your boss doesn't really care, it's probably its own problem, but you know, your file should have something in it. I guess in my next presentation we'll get to talking about how you can use the computer to sort of substitute for your file, but even then the information or the documents or whatever is still there. We used to be able to, I would get my file, and I always loved was I would get my file and I would see, we would get our order of appointment, and what I liked was stapled to the order of appointment was the jail printout sheet. And the jail printout sheet would have all this great information, but mainly would tell me what charges he was in for, when he got out on those charges, and what charges I was assigned in the initial appointment. Because how many times have you walked in the court and the guy starts talking about these other charges? Like, what other charges? When were you in on those? I don't have any idea. Where? And then he's looking at you like you're supposed to know this. And then I'm going, well, I probably should know this, I'm your lawyer. But then then I can go through my file and figure it out. And it's just little things like that. Whatever it is, that's a pet peeve of mine. Whatever it is of yours, figure it out and include it in your file. Defender data, again, I'll talk about that in a little bit, but time management, and they're sort of connected with defender data. Know yourself. There are some things you suck at, and there are some things that you're good at, particularly with time management. It's a huge challenge for everybody. It doesn't, young, old, experienced, computer savvy, not. It really, there's some level of time management that all of us are not good at, and a lot of us are. I think the important thing is to really just be honest with yourself about it. Let's see this next one. Yeah, use a calendar. I've gone through every permutation of calendars. I used to just use a pad, and I would just write down what's important. Then I went to the big calendar where I'd write it on my desk. Then I went to the computer. Now I got the computer and my phone. Hopefully they're synced up with each other. I haven't really ever used Defender data as my daily calendar, but in there is obviously calendared items. You just need it because there's just too much going on. You got to work obviously with your assistant to figure out ways the two of you are going to stay on top of the things you need to stay on top of. All right, I love this part. What do you think the answer to that is? No? Yeah, you're right. I think it's no. I know that it's like you think the gods of public defense are going to come down in here and scold you because you're not treating all of your clients fairly, but you are. If a guy's charged with murder and a guy's charged with shoplifting, who wants to usually talk the most? The shoplifter. The murder client, or whatever serious offense, in my experience, there's a disproportion. The guy with the more serious charge tends to not want to talk as much as the guy with the least serious charge. They go in opposite directions. I haven't figured out psychologically why that takes place, but the fact is, it seems to be a good rule of thumb. But that goes to your time management. I mean, you can't literally go through every piece of paper and every file with an equal level of intense focus or whatever you want to say. You just can't. You got to triage. It's just the reality of what we currently do. I don't know any other way to give it to you. That to me is the reality. The benefit of that approach is, one, I think it takes a little pressure off of you if you're thinking I'm supposed to treat everybody exactly the same. You treat them exactly the same with respect to generally wanting to help them and respect them and all of that, but the outcome doesn't have to be exactly the same. You don't have to spend 3 hours with every client. I think the triaging helps because you figure out, I can move this case fast. Now, there are some shoplifting cases or other those cases that are freaking much harder to resolve than a murder. That happens, and you end up having naturally to resolve because the guy's got all these side issues, and it's just complicated in not as serious a consequence way, but it's still complicated for whatever reasons. Maybe sometimes the client itself is difficult to deal with, but figure out a way to move your case. Unless, I mean, the overall rule of thumb being, if it's not in your client's best interest and he agrees with that, there's two parts to that. Not in your client's best interest, and he agrees with it, then there ain't anything wrong with you sitting on a case. But sitting on a case just for the sake of sitting on a case, because you generally have this rule of thumb like, I don't do prelims because prelims never give me anything. I don't know, I'm pretty sure that's malpractice, but same thing with dealing with the client. You're not going to tell them, or you're just going to sit on the case just because that's what you do. It ain't your case. And I found that clients are pretty savvy most of the time. They're able to tell you, I want to sit on it. Yeah, you're good. I'll stay here at the jail and you won't even hear from me. It's the guys you usually don't talk to in that way, don't have that conversation, are like, what, you never told me. I don't know, what's going on? You're going to get me out? What's going to happen? Well, sometimes just a little conversation will do it. Sometimes not. That's okay. I don't agree with delaying for delay's sake if it's not strategically part of your plan. Because then what you're really doing, and I'm as guilty of this as anybody else, then what you're really doing is you're delaying it because you got all these other cases that in your head are more important, and you don't feel like you can really get to that case, so you're going to delay that case and focus on the ones you really think you have to focus on, and then whatever happens is that guy comes and bites you in the ass because you kind of put him off, and you never really explained what was going on, and it really just kind of comes back to you. My ass has been chewed up plenty of times because I've done that. So it's not a easy thing. Explain it. Some guys want to delay. Some guys want to get into court right away. I had a guy charged with murder, and he was brought over from Maryland, and they brought him over here in this old murder case, and he had a probation violation. And he already was like really into his case. I didn't do this. He had all these, he's very much asking me questions all about his case, all about his case. And then the probation thing comes up, and he's like, all right, I want to go do this, let's go. I'm like, you've been gone from South Carolina for like 2 years. Do you think the judge is not going to put you in prison for violating your probation? Why no, I just want to get my time over with. You're just telling me that you want to go to trial for murder. Yeah, I know. So we ran round and round and round with me trying to explain to him, you realize that when you get sentenced on your probation, you're going to go somewhere in South Carolina that's probably pretty far from here. And then when the trial comes up, you're going to be complaining to me, well, we never spent any time together to prepare for your trial. It never dawned on him. He was like, okay. But he didn't click. I made my effort with him. If ultimately that's what he wanted to do, I tried to hold it out as long as I could. Eventually, actually, that case got given out of our office for, I forget why. Oh, he didn't like me anymore, so he got a new lawyer. But that was just a point of, he thought what he wanted to do was to go quickly. I didn't think that's what he wanted to do, but I also didn't think that it was my place to just simply go, I made a decision, we're not doing that, and not explain it to him. Now, ultimately, if we really didn't meet eye to eye on it, I don't know, I guess I would have just decided in that moment, would I give him what he wants, or would I just do what I thought was strategically the best thing? Eventually you get to a situation where you're just going to have to make the best professional choice you can. But most situations, I think, can be worked out as long as you have that conversation. All right, analyzing your client's case, when do you do it? I don't think you do it too quickly. Certainly not the first time you meet with them. I don't think you do it before you literally have to. And certainly not because your client just wants you to do it. You never know what's going to come out, particularly in discovery, in the discovery you didn't get, all that kind of stuff doesn't, it's a little bit difficult to give the prediction, and you're going to be locked into whatever you said the first day. So, and I will literally tell my client, you don't have to decide right now. There will come a time when I'm going to tell you, I got to know. But right now, I don't want you to decide. And I'll hold them out. And even when they want to tell me, I'll just, don't tell me right now. I don't need to know about that. I don't know why that one's at the bottom, but it's out of order. You know this to be true in terms of how much information you need, but I think you still have to work on managing the information coming out. because your client always wants to get ahead and wants to change around, and that's usually a big challenge whenever you're interviewing somebody. It goes back to the note taking, but it also goes back to how are you thinking about the case and what are you telling the client? I mean, I know I was concerned about telling the client, like letting him into my head early on, and now I'm like, look, hold on, I can't get there. You just have to sit there for a second. Let's go through this part, then you can come back and tell me about that. I mean, early on, I was much more worried about what I was going to tell my client. Like I had to hold all this stuff back. Now I'm pretty much telling him just about everything. I just let him into what's going on in my head. But there are crucial things that I will control and hold back. Not information, but how I'm going to go about doing what I'm going to do. But I'm not going to give in to his anxiety, give in to my ego, give in to my own anxiety. I'm not going to let him rush me for the sake of him getting an answer that he thinks is there that's never going to get there. I'm going to try to control the situation by controlling myself and how we meet out the information. When you tell the client, like I said, I don't think it's when he has to know something that you tell him. I don't think you tell him sooner, and I don't think you tell him later, obviously. And your professional approach is figuring out when you professionally think it's the right time to tell somebody something. But I think a lot of times we do use that either as a reward for the good client or a punishment for the bad client. We sort of will give them, okay, well, why don't you just figure out what you want to do? You don't like the offer? Why don't you tell, we kind of lash out. We have that tendency to do that, and I think we have to control that. Do you spend enough time with your individual client? A lot like that question I asked you. Well, I think there are two answers. We fall into both these categories, not enough and too much. And they don't necessarily always fit the right person. And it's just something that we just have to work on, and a lot of times I'm conscious of it. But it's not based on the charge. There are some people that I'm willing to spend an hour with just because, and they could be shoplifting or a small charge, just because the person really does need my help. And I need to flesh out some things. And then there are guys who, they should need all of my help, but they don't think that they do, and then you're not really getting anywhere. So my time with them, again, doesn't fall into that category of my philosophy. I'm supposed to spend equal amounts of time with my clients and so forth. Like we're going to, get kicked out. They're going to take our PD card away from us. We're somewhere probably in the middle, but a lot of times we go into the hall, the state can't do anything right. It's our job to be against the state. They're a bunch of jerks. And of course that's true on some occasions, and you get frustrated. I get frustrated as much as anybody else. But it's not true in and of itself. And then the client is guilty all the time because we get a little jaded and tired of hearing lies and being told lies and stuff like that. And you just got to catch yourself when you start feeling that way and you realize that's probably not entirely accurate, although there are going to be people who do exactly fall into those categories. For the most part, most clients aren't into that situation. I think this is important because it's part of what we like because we're lawyers. Part of what we like is getting a good issue. We think it's cool. We think it's interesting. Don't tell your client about it, even if he asks you about it. Make sure you thoroughly looked at it, you figured it out. Does it apply to him? Does he even need to know? I mean, to me, one of the worst things to do is just to go, oh, you got this great issue. It's a Fourth Amendment issue. I love these issues. Who's won a Fourth Amendment issue consistently? I don't think I've won a Fourth Amendment issue in 13 years. I know I haven't. So while I have to analyze it, and at some point I'm going to have to address it with the client, because he needs to know it's there, but then he needs to understand the realities of whether he's going to win it or not. But I'm a fool if I'm going to rush in there and go, oh yeah, the cop, oh, we're golden, or even trying to talk about it in a way that you think is responsible. But if you stopped and kind of paid attention to the context of your conversation, you'd realize that the client's not going to take it that way and is not taking it that way. You need to step back. You need to slow him down and realize, that you may be setting him up for an expectation that you can't live up to. And then guess what's going to happen? He's going to ask for a trial. He's going to want you to file the motion, and then you're not going to win. And then he's going to be and then you just set yourself up for a problem all because you allowed yourself to run away with an idea that is really interesting. And that's coming from somebody, I love those issues. I've had the great flexibility and opportunity to set up a couple of cases at the trial level, take them to appeal, argue them in the Supreme Court, argue them in the Court of Appeals. I love it. To me, that's fun. But I still don't sit down and talk to my client about those things unless I really feel like that is a viable and good option, or I've done it in a time where it's appropriate that he's gonna, I've armed him with enough things to be able to make what I think is the right choice. So I'll leave it as my last slide. You do have to go home. I don't think I've ever gone home where my desk wasn't a mess, so but I'd be happy to answer any questions. I'll try to go fast because I was trying to catch you up on time a little bit, only to come back up here after your break and do the next presentation. But thank you. I'm happy to answer any questions you have now or even after.